Proceed whenever you're ready.
Thank you very much, Mr. Chairman and members of the committee. Senate File 514 is an elections omnibus bill. And Mr. Chair, I do have an amendment, and I think if we would take care of that prior to explaining the bill, I think it would fit together, and that is the A16 amendment.
Okay. Thank you, Ms. Senator Kiffmeyer. We'll wait till that gets passed out.
Yes, A16. Mr. Chair, I can quickly walk you through the bill, amendment.
Let's move the bill first. Senator Matthews is going to move the bill. Senator Matthews moves the amendment A16 amendment. Senator Kiffmeyer.
Thank you, Mr. Chair and members. This is a amendment after the last committee in meeting with a variety of stakeholders. This amendment is response to that. And so first one just takes care of some technology issues, grandfathers in equipment purchased prior to the date of enactment. So it helps take care of some of those issues. The next one is also having to do with just some absentee ballot change language that helps clarify administration. And this is listening to the county administrators and some of that. So there's areas in that we do. The reviser had a couple changes on line 14 and 15. And then, again, more clarifying language on 16 and 17. The effective date also clarifies when that change begins. We've also added something that is called interactive video. You've probably heard this from some other bills as well, you probably will be, so that instead of driving to a location, you can use an interactive video in order to take care of business, saves a tremendous amount of money and time. Another effective date, another use of the certification process, and then on the page 2, just more clarifying language. And so, Mr. Chair, that is the amendment. I've asked for your support.
Okay. Again, Senator Matthews moves the A16, if I've got that right, amendment. Any questions, members? Seeing no questions, all in favor say aye. Aye. Opposed? The ayes have it. The A16 amendment has been adopted. Senator Kiffmeyer.
Thank you, Mr. Chair. And so, members, Senate File 514 has 4 articles to it. The 4 articles are grouped by, the first one is mainly just election administration changes. Your summary will go through a variety of them. Many of these were requested possibly by the Secretary of State, by the League of Minnesota Cities, other stakeholders. One of the things that we want to do all the time when we hear testimony is to be able to respond to those concerns. And so several of those were done in this Article 1. The second one, and also Article 1, has the election equipment, and this appropriates $5 million, 75-25 match for e-poll books, 50-50 match for other election tabulating and assistive technology equipment. And in the amendment that we put on today, this appropriates the money in 2018. It carries forward until it is expended, so it makes sure that the convenience of using those dollars and carrying that forward will be there for them. Article 2 has to do with uniform elections. And, Mr. Chair, right now in Minnesota, the door is wide open for the many different, hundreds of different election dates occurring all across Minnesota. They have changing times, they have changing locations, changing polling places. And we hear complaints all the time about voters being confused, not being able to vote because they couldn't find that changed polling place. And so in response to that, this creates 4 uniform election dates. And Mr. Chair, to summarize for your members, we've worked with the Minnesota Association of Townships and others as well to come up with these 4 dates. We've also set a standard uniform hours statewide. Equal treatment of the voters includes the hours of voting. Want to make sure that everybody throughout the state has those uniform hours to have the same equal opportunity to participate. and then uniform polling places. So by December 31st of the year before, those 4 polling places on those 4 dates, those locations would be established. And then for the rest of the year, you'd have the same polling place, the same hours, and the same dates statewide. In Article 3, school election administration is moved to the auditors. The auditors are really your local government chief election official experts. They are involved in all elections, no matter whether they're a city or a township or a school district. But in particular, the school districts have been put in a situation of taking on election administration, which is really not their expertise. Their expertise is in education. We want to preserve their time for doing those things that they have the expertise, and the county auditors have the election expertise. In this language as well, we set up a process for multiple counties being involved, having a coordinating county. We've also set up a process for payment of services from the school districts or from a local in which they need to be compensated for that time. And so that language is in here as well and has worked its way through the process. Article 4 is a bill that has to do with standard. First of all, the first several sections, to let you know, currently in Minnesota, the Secretary of State receives data from the Department of Public Safety, from the Department of Corrections, and from the courts. This is in regards to administrative challenges. That means they get a person that comes forward through the election administration process that has either been declared by a court in a very open and transparent process that the ward is unable to vote. And so their right to vote, they do not have the competence to vote, so their right to vote has been revoked. In regards to felons from the courts or the Department of Corrections, again, in accordance with the Constitution, that they are not eligible to vote till they have finished all their time. And so they are administratively challenged for that reason. From the Department of Public Safety, we would have non-citizens that may be lawfully here in the state, but they are not citizens and not eligible to vote. If somehow they have gone through the process of applying for a driver's license or an ID card and have somehow checked the box, they are still not allowed to vote. And to also remind you that in our Minnesota Constitution, in the article on elections, it says that those who do not have the mental competency to vote, those who are not citizens, those who are not 18 on election day, those who are felons who have not completed all their time, those in that situation are not only not eligible to vote, they shall not be permitted to vote. And so the system is required to prevent them from casting a ballot. 2 reasons, by the way. We have documented cases where those who are wards of the state, in Crow Wing County in particular, a father found out that his son was taken to vote, and he did cast a vote, and yet still had a court order that revoked his right to vote. The father felt this was abuse of his son. It was taking advantage and exploiting him for a political purpose. His son could not get to the polling place by himself. He was taken there. And so he felt the system failed him. Sadly, a year later, on the date that this happened, the father passed away of a heart attack. And this made him very concerned about the care for his son, that he could be exploited or manipulated into doing something that was clearly, by court order, unable to vote. And for those who do have a felony, if they do perchance get through the voting system, then they have committed another felony. And the last thing they need is to be allowed to commit another felony. So the system needs to recognize they're not eligible and then shall not permit them to vote. And so by gaining these reports, which are again through the process, but the problem we still have people, even in spite of this, and so the system needs to do more. In Article 4, we've taken those same reports that are currently coming, but we standardized the language. Over the years, technology has changed, and this is a section of law that had bits and pieces. So we went through those areas. No policy has been changed, but what we have done is standardize the language so that it is more clear. One thing that is new in this area is for those who have been administratively challenged, then they are sent a notice within 7 days after the challenge being applied. Within 7 days, they would receive a notice to their address on record notifying them of the challenge, the reason for the challenge. In addition, in this law, it includes an appeal process. If they feel that this challenge is incorrect, even though it has come from a court, they have that right. I feel that's very important to make sure we protect in every way possible. And so they have an appeals process in that notice, giving them that opportunity to do that. And then after that, when it comes to the polling place on Election Day, any challenges that are on the ballot, we would not have any self-certification, reminding you that this information has come from a court, has come from the Department of Corrections, has come from the Department of Public Safety. And as the Secretary of State testified, he has confidence in the accuracy of the report from the Department of Public Safety in particular. These other ones are coming from the court, directly from and then corrections. And so in this case, though, sometimes there's a time lag between when the administrative challenge is applied and the election day occurring. There is a little bit of a time process there. We're confident of the data. We just want to make sure, though, that we have a system in place for them to make sure we protect any opportunity that they are eligible to vote and need to be permitted to vote, and that is why we have provisional ballots for these administrative challenges. It's one last opportunity, a fail-safe opportunity for them to make sure that the most current data is available in the system. The voter themselves would not need to come in and do anything. It's an administrative challenge within the county office that applied the administrative challenge. They would review the most recent data sent from the courts, corrections, or public safety, and if that challenge has been removed through that information, then that provisional ballot would be counted. If the information is accurate and is the most recent information, that provisional ballot would be rejected. That would be done administratively, just as it was applied administratively. So, Mr. Chair and members, with that, that is Senate File 514. Thank you, Mr. Chair and members.
Thank you, Senator Kiffmeyer. Members, before we have a testifier, do you have any questions? Let's go right to the testifier then. I believe Catherine Thomas, League of Women Voters. Catherine. Is it Tom Sick?
Tom Sitch.
Tom
My husband's
Sitch.
from the range.
Oh, there you go.
Yeah.
Okay, if you'll give your full name again and then continue.
Yes, my name is Kathy Tomsich, and I have been a head election judge for over 12 years in Ramsey County. I'm a volunteer lobbyist for the League of Women Voters, Minnesota. League does not support or oppose any candidate or political party. We work to ensure that voting is free, fair, and accessible for all citizens. The League of Women Voters strongly opposes Senate File 514 for several reasons, but I will focus on two of them. Requiring challenged voters to vote a provisional ballot is an unnecessary and costly change to our election system. No data set has been presented that tells us that our current system for handling challenged voters has resulted to any significant extent in these types of changes. Provisional ballots will make elections more complicated and cumbersome for the voter, election judges, and election officials. States that have adopted provisional ballots have found them to be expensive to process. Minnesota cities and counties will be burdened with the cost of processing those provisional ballots. Challenged voters will no longer know on Election Day if their ballot will be counted or not. This will discourage voting. We oppose making public the party affiliation of election judges. Under current law, election officials already know the party affiliation of election judges and are required to staff polling sites with judges from each major party. Again, no data set has been presented to indicate that election judges have been a threat to the integrity of our election system. Making an election judge's party affiliation public will make citizens less willing to volunteer and make it more difficult for election officials to recruit judges. Minnesota citizens are proud of our election system, as evidenced by the high rate of voting in our state. Along with being costly to implement and completely unnecessary, Senate File 514 will burden our election officials and discourage voters from voting. Please vote no on Senate File 514. Thank you.
Thank you. Senator Osmek?
Thank you, Mr. Chair. Thank you for your testimony. I have a question for you. You indicated that other states have gone through provisional balloting systems. Can you provide any numbers as far as how many and what percentage of the vote takes place under provisional ballots in other states?
No, I couldn't. I don't have that information.
So,
I don't
Mr.
have
Chair, I get a little bit disappointed when you point to Senator Kiffmeyer saying she has no evidence, and you actually have other states that have provisional balloting systems, and you have the statistical information, but you don't choose to present it. I guess I get a little, Mr. Chair, I get a little disappointed that if there are numbers, why wouldn't you bring those to us to support your case?
Chairman,
Ms.
may I
Tom
respond?
Sitch. Yep.
What I'm concerned about is that we do not have any data presented that indicate that our present system of self-certification has resulted in a significant number of ineligible voters being allowed to vote. By significant, I mean enough to justify this major change in our present system.
Mr. Chair, I can respond to that.
Senator Kiffmeyer.
Thank you, Mr. Chair. 47 of 50 states do provisional ballots in the country, 47 of 50. 3 of them are Election Day registration states. And so this is going on throughout our country right now. I'd like to call your attention to the fact that just recently, in the city of Wilmer, there was an issue with felons. So we have documentation in regards to that, Mr. Chair, and I'll certainly be able to have more. Minnesota Majority did a study in regards to another election, and it was a significant number of felons that did vote and were found afterwards to not be eligible to vote by an intensive study. So it is an issue, but more importantly, we have the Constitution. It is that they're not eligible and they shall not be permitted.
Senator Lane.
Thank you, Mr. Chair. And to the League of Women Voters, what is it now in determining the partisan standing of the election judges? How does that stand today?
Ms. Tom Sitch.
How is it done?
How, some of them, you have to have an equal Democratic and Republican number of election voters, but not, excuse me, but not all of them have to have a partisan standing. Is this the case? Could you explain that?
Right. You
Ms.
could,
Tomsich.
as an election judge, you could say that you're independent, you're not affiliated with a major party. So if you are affiliated with a major party, you should state what your affiliation is. And if you're not, you would say that you're independent.
And then are they balanced?
Actually, I'm not sure. It's my understanding that every major party should be represented at a polling site.
Right, as I understand it, there has to be an equal number from each major party.
I
Ms.
don't
Tomsich.
believe that that's required, but I can't answer that. I think that Senator Kiffmeyer would be able to answer if there are equal numbers required. I think that would be very difficult to do.
Senator Kiffmeyer?
Senator Lane.
Senator Kiffmeyer?
Senator Kiffmeyer, do you
Thank
have
you,
any
Mr. Chair.
response?
Thank you. And Senator Lane, yes, there is required in statute to be an equal number of Democrats and Republicans.
Senator
And,
Lane.
and if a person was associated with neither party, they could, that would be fine too?
Senator Kiffmeyer.
Mr. Chair, Senator Lane, you said something about if they were from either party.
If they were not associated, didn't consider themselves either a Republican or a Democrat, they could still be an election judge?
Senator Kiffmeyer.
Thank you, Mr. Chair and Senator Lane. Let me just step back a little bit. Why do we have partisan election judges? The reason why, and again, I served as an election judge for 11 years as a Republican election judge, and I very much enjoyed working with my Democrat election judges. We work together very well in the polling place. But the greatest value to the voter is by having each of them in equal numbers in the polling place. You have a check and a balance to each other. They overlook each other. They are looking out for the voter in the process. So it's a tremendous benefit to the voter. And being honest about it and saying, I'm a Democrat or I'm a Republican, and that is, I think it's sad these days when political parties are castigated, that somehow in every other part of this world we have the Lutheran Association, the Administrators Association, we have the National Conference of State Legislators. We even have an association. Political parties have an association. That's their freedom and their right under the Constitution. But in the polling place, when you have each of them declared in regards to the partisans that they are, they work to the benefit of the election system and to the voters.
Senator Lane.
And, Mr. Chair, what I was getting at is that it is established that election judges, if they have a party affiliation, that will be balanced. They will make sure that we have chosen election judges that they are balanced so that they can provide that balance in. But they don't have to have a party. The point is about making it public. In Minnesota, to this point, we're going to have it a little bit different now as we get into public primaries for partisan choice for president. But at this point, you do not have to register anywhere publicly as to where you stand with your political affiliation and change that as you so choose. You don't have to do this. In Minnesota, what our partisan stand in, except when we're in the legislature, is private business. And what this does here in this particular bill is says that if you want to be an election judge, you have to state publicly, it has to be in writing for anybody to determine, anybody to see what your partisan standing is. It is clearly handled in those who are choosing the election judges so that there is this balance, but nobody has to have it on a public record what your partisan standing is.
And Mr. Chair,
Senator Kiffmeyer.
I think it's really important to realize here that any election judge, if they do not wish to choose a major political party, that is their right to do so. However, the system does say that when you have election judges, you need political party balance. And so those who are willing to do that should be able to do that and work on behalf of the system and work with the statutes as required.
I'm sorry, who's up?
Thank you, Mr. Chair. To Ms.
Senator Osmek.
Ms. Tomsich, I just did a quick search of the last election, and your testimony indicates that provisional ballots would provide an undue burden. Is that correct, what you were saying? That's an undue burden and very expensive?
It would complicate our system. It would make it cumbersome for the election officials, the judges, and the voter. And it would be costly, too.
Thank you, Mr.
Senator
Thank you, ma'am. Thank you, Mr. Chair. I did a quick search here, and in the state of Wisconsin, who's a little bit larger in population than we have, in the last election in November, they had a grand total of 750 provisional ballots cast. That's not even one per precinct. And I didn't go to check how many precincts actually had these, but we're talking about maybe one. How do you believe that if it's one provisional ballot out of the tens of thousands of ballots that are being cast, that one ballot out of every fraction of a percentage would create an undue burden and undue cost to Minnesotans?
Ms. Tomsich.
Okay. As each polling site would have to be prepared for a possibility of a provisional ballot being cast. So we would have to have the separate envelopes, the storage for those separate, the ballots that are cast and put into the envelopes. We would probably have to have an election judge who would be handling provisional ballots. So that would be staffing and equipment, basically. And then you would have to have a procedure set up for delivering those cast provisional ballots after, at the end of Election Day, and then they would have to be stored someplace until they are certified by the county officials looking at the statewide voter registration system database. That's labor intensive here. So there may only be one ballot that's cost, but every polling site would have to have all of those provisions available for that one ballot. So
Senator
indeed,
Osmek.
it would be very expensive for one ballot.
Senator Osmek.
So, Mr. Chair, thank you. So, considering that the state of Wisconsin currently does that, they obviously would have some information for you available to support that statement. Do you have any information that actually tells us how expensive this might be in addition to the current system that they have?
Excuse me, Senator Torres-Ray.
Thank you, Mr. Chair. I feel like we are putting you in court, and I apologize for that. I appreciate that you are here, but Senator Osmek, I do not believe that we inquire this specific information as if she is in court. That's just, I'm uncomfortable with the way you are presenting. I appreciate that you're coming, and we many times have testimonies that we completely disagree and we believe have absolutely no merit, but we do listen, and we do not ask that they be prepared with empirical evidence and research that supports their testimony, Senator. I apologize, Mr. Chair, but I do believe that this is going beyond kind of the protocol of the Senate.
Mr. Chair, I'd just
Senator
like to
Osmek.
respond and then I'll move on. Well,
Let's do
Senator
that.
Torres-Ray, when somebody comes forward and makes an allegation where you can very clearly get that information, I think that's important for us to have that information in the decision-making process here in the Senate. That if a person wants to make that statement, having something to back it up certainly is very helpful in determining whether this would be terribly costly. Because right now, all I have is her statement. When across the border in Wisconsin, we actually would have some empirical evidence to use.
Okay,
So I appreciate your comments.
Senators, thank you.
Chairman?
Let's move on. We've got time restraint here, so if
Okay,
we
I
could.
did have one comment. I think that is a good point. There is no fiscal, from what I have seen, there was no fiscal note attached to this major change in our system. And it seems to me that the fiscal note should have been attached to something this significant.
Thank you, Ms. Tomzak, for your testimony. Okay, are there any others that would like to give testimony this morning on this bill?
Mr. Chair, I have a handout.
Okay, we have a couple other people that are looking at giving testimony. And yes, if we can get that handout, that'd be great. If I see two people here, if two people are going to give testimony, you can take a seat. Both of you? Sure. Okay, if you want to give your full name and then your testimony.
Mr. Chair, members of the committee, I'm Ken Sulam with the Minnesota Association of Townships. I'm going to apologize to Senator Kiffmeyer. She's been very...
Excuse me, Mr. Chair. Could he speak closer to the microphone?
Yep,
Sorry.
thank you.
Is that better?
Yes.
I apologize to Senator Kiffmeyer. I hadn't intended to be up here today because she's worked with us very closely on fixing the areas that we had concerns on. But somehow, during the course of our conversations and reading of previous renditions of this bill, I missed the repealer of 205.175, which is the uniform hours provision. And for town elections in particular, it's very common that they have the meeting in the afternoon, and then they have their election 5 to 8. That would not be possible now under this provision. And so I just wanted to flag that, and I'll certainly work with Senator Kiffmeyer as this moves along. But I just had to flag that because that is a major, major change for our folks.
Senator Kiffmeyer.
Yeah, thank you, Mr. Chair. There's no intention in any of this language to include townships in that. We know that they have, matter of fact, there are 4 dates, and then the 5th date would be the township election. And so they have their own unique situation. They have polling places with 15 voters. In my area, we have nearly 10,000. And so those variations, we've left that for the townships. So I'll work with them to make sure that's the case.
Mr. Chair, I'm very confident that we can work that out. And again, I apologize, I didn't catch that earlier when we were fixing the other pieces.
Okay, thank you.
Okay. The other testifier, give your full name and your testimony.
Mr. Chair, committee members, my name is Michael Stahlberger. I am the Director of Taxpayer Services in Blue Earth County. In that role, I serve as Elections Administrator as well as other duties associated with Auditor, Treasurer, and Recorder functions. Today, I'm speaking on behalf of MACO, the Minnesota Association of County Officers, and we would just want to provide some feedback on Senate File 514. First off, we do appreciate the willingness to work towards appropriating funds for technology grants for election administrators. That's greatly appreciated. However, we would like to note that the $5 million appropriation is not enough to meet the needs that election administrators have recognized throughout the state. We also appreciate Senator Kiffmeyer's amendment to the bill regarding the poll books and electronic registers of that nature that were in place before the provision she has in this bill. Being able to grandfather in that technology will save county administrators for elections from having to replace equipment that is relatively new and still useful. Our final point that MACO would like to make is regarding the administration of school district elections. MACO strongly advocates for flexibility at the county level in terms of how elections are administered, including being able to work with school districts to determine who is in the best place to administer that election. MACO continues to be willing to work with Senator Kiffmeyer and to make any changes and provide feedback that we can to this piece of legislation.
Thank you for your testimony. Any questions from members? Yes, Senator Torres-Ray.
To the testifier, could you expand a little bit more on the concerns about the school districts? I am concerned about, obviously, the provisions that talk about providing the responsibility to the school district. I wanted to ask the author about kind of the funding provisions related to, how the school districts will manage that. But could you expand on your concerns about this transfer of responsibility?
And could you give us your last name again?
Sure, Mr. Chair, my last name is Stahlberger, Stalberger. And Senator, our concerns related to that provision are mostly tied to the way that county offices administer the elections right now. For example, in Blue Earth County, we do not have dedicated staff that administer elections. We have about 60,000 residents, 30-some thousand registered voters, and with our staffing needs, we're not able to have somebody dedicated just to elections administration. We bring in staff and we ramp up our staffing during the elections times. So what works well in Blue Earth County is we have good partnerships with our school districts where they're able to administer the elections with support from our offices. And so that concern is shared through other counties as well, where they would have to administer additional elections, which would put added burdens on their staff that are being used to work in other areas when it's not a typical statewide election.
Thank you.
Okay. Any members? Is there any other testifiers that would like to speak on the bill? Seeing none, Senator Kiffmeyer.
Thank you. Thank you, Mr. Chair. And as always, I continue to work with the stakeholders as you have seen as we've gone through the process. To let you know, though, on those, when you go to 4 election days a year, the efficiency and the cost savings are great. And just reminding you that instead of having several and varieties going on and changing locations, just that alone, I think, will be very, very helpful no matter what level of government you are. And also, most especially, because elections are for the voters first and foremost. This is a very voter-friendly process. And so, Mr. Chair and members, we've gone through the election administration here, and we've worked very hard to make sure that the process is as efficient and as user-friendly as possible to both the voters and to the election administrators. And I will continue to work with those, such as the Township Association and whatever needs may be. And the handout, as you will see, most recently, even just this year, and every time, I think it's important for us to do the best we can. So, Mr. Chair and members, with that, I ask for your vote of support. And, Mr. Chair, I believe this is going to
Transportation, I believe.
transportation, that's right.
Yes. Senator Lane.
Thank you, Mr. Chair. And the questions I have weren't for the various testifiers as much as for the author, so
Sure.
now I hope we have the discussion. First of all, I did look up and see that in Arizona, where the most provisional ballots were in history, they had almost $500,000 in costs just for the provisional ballots. So you can look that up yourself on pewtrust.org and see the costs of provisional ballots. So there is a cost. Of course there is. Then I would just like to say, what is the penalty for a felon, a person who has a felony, voting because perhaps they thought they were able to vote? What is the result for them if they vote when they have a felony?
Senator Kiffmeyer?
Mr. Chair and Senator Lane, when you have a felony and you're not eligible to vote and you vote again, that is another felony.
It is another
Senator
felony.
Lane.
Thank you. It's another felony, a felony. So if they have, we have some incidences in a few here and there, and they always say, I didn't know I couldn't vote. So we then, I believe it was last session, said the Department of Corrections will make it clear when somebody is released from prison and they're still under their probation, so they're still under their felony, they make it clear to them that you are not to vote. Because if you do, you will be back in jail. You will be back with a second felony. Nobody in their right mind is going to risk a felony when it's so obvious that they will be caught. And then,
Mr. Chair,
Senator
in
Kiffmeyer.
response to that in particular, it's very important to note that they're saying they don't know. In this bill, they would receive a notice and an appeals process. And so they do not have that now. So this bill would include a notice to them so that in addition to what the probationer officer does, in addition to that, which they're explicit about all of the things that they go through, that when they're on probation, what they can or cannot do, carry a gun, have a gun, whatever those things may be, voting is one of them. Those are the rights that they lose when they're in that situation. But my bill would have notice, which they have not had before, as an additional effort to make sure they know.
Senator Lane?
I think that's a very funny way to give felons notice when they leave the jail. They're given notice by the Department of Corrections. To have this process, simply to give them another notice, is rather an odd way to push this bill. But I would also like to ask, how many of the states that have provisional ballots have same-day registration?
Mr. Chair, 3 of them.
Senator Kiffmeyer.
3, only 3. So out of the 47, only 3 have same-day registration. And as I understand, the idea of provisional ballots in the beginning was simply because you came and you wanted to vote, but you couldn't register. So you were able to provisionally, you say, yeah, you have all the reasons, you have all the ability to vote, but you're not registered, so you can't vote. So they had a provisional ballot for those people to be able to vote. And then it would be clarified that they had all the reasons to be able to register. They could register after the fact, and then their vote would count. But we have same-day registration, so we don't need provisional because you're not registered yet. And as you say, only 3 of them have that. The original reason for provisional ballots was for registering to help people vote, not to prevent people from voting.
Well, Mr. Chair,
Senator Kiffmeyer.
in those other states that they do, that is provisional ballots, they do not have same-day voter registration, so those provisional ballots are largely for that purpose. Say their name was incorrectly not on the roster list, and that is understandable. However, all of those other states also have a much more demanding process than Minnesota does in regards to administrative challenges such as felons, those who are non-citizens and others as well. So if you just isolate that, you don't give the whole context. And 3 of the same-day registration states do have provisional ballots.
Senator Lane?
And Mr. Chair, Senator Kiffmeyer, are you aware of the ERIC, I forget the Electronic Registration Interstate Compact or something, ERIC? Are you aware of that bill that we passed a couple years ago?
Senator Kiffmeyer.
Yes, Mr. Chair, yes.
And what does it do?
Senator
Mr. Chair,
Kiffmeyer.
it is a national list data reference, but it is not complete. There are many states that are still not involved with it. so it's not complete. But most importantly, we have Minnesota law, Minnesota Constitution, Minnesota processes. And Eric, though it does take care of some areas, it does not deal with the issue of challenges and also making sure that they're not permitted to vote, to protect them as well from any other felonies.
And Mr.
Senator
Chair,
Lane.
Eric actually does, it's a growing organization so that the number of states involved are increasing, but it is a compact to have our voter rolls checked on an ongoing basis to make sure that we don't have, that we can clean up our rolls because we're checking with other states and their registration also. It's an excellent idea. And then my last comment is I understand that when our Constitution was set up, and it says that people under guardianship cannot vote, we didn't at that time have the guardianship process we have now, where people are guardian for a relative, for instance, who has become, needs help with their finances or something. At that time, guardianship in the Constitution meant Native Americans. Native Americans were not allowed to vote. Native Americans were wards of the state. That was the guardianship, and I just put that out there to think about. Thank you.
Any other members? Senator Torres-Ray.
Thank you. Senator Kiffmeyer, I am just curious about really the reason for having the judges' party affiliation be public data. Could you expand on that?
Sure.
Senator Kiffmeyer.
Thank you, Mr. Chair and Senator Torres-Ray and members. When you cast your ballot, who you vote for is a sacred right. It's a privacy. It's absolutely crucial. There are other things, though, that are in the public interest. So having election judges and political party balance, having that being available to the public is a public benefit to know. Now, it's not that you wear a name tag when you're in the polling place on election day, but the political parties have a responsibility to make sure that they provide sufficient election judges from their political party to provide that party balance. Their absolute frustration is the inability to get the information that says which political party are these election judges. So if you are short either political party, that we can help you get the party balance that is so important to the integrity on election day in the polling place. Without being able to have access to that information, how can they do their part of the job in making sure that they provide sufficient election judges from their political party? When I was an election judge myself, I also was active in my political party. I worked with the county administrator to help make sure that if they were short our political party in the process, they would let me know. And I would make sure that I contacted people and provided what they needed. And so there is a public good, but in order to exercise that and do their job, they need to know.
Senator Torres-Ray, follow up.
Senator Kiffmeyer, it would seem like it is the opposite. I would like for the judges to be absolutely neutral. It would be to the disadvantage of the process that this information is actually made available. I really appreciate that I just don't know, that I can trust this judge fully, whether he or she is a strong Republican, a strong Democrat. I just want the integrity of the process to move forward and to work for me as a voter. Mm-hmm. So the implication that we actually need to publicly know how you vote and what is your party affiliation in order to have integrity into the process just doesn't make any sense to me. Don't you think that it's actually the opposite? That we shouldn't actually know, because the recruitment process and the credentialing processes should be totally neutral, that we shouldn't, as voters and as a system, actually should require that information, because it does the opposite when we actually know that we are arriving to a Republican district, for instance, and do we need to know that all of it? Yeah, probably they had a hard time recruiting Democratic judges, but that should not interfere with the integrity of the process. I don't understand that answer.
Mr. Chair,
Senator Kiffmeyer.
Senator Torres Ray, there are, when you talk about neutral, that is why party balance is so important. That's how you get to neutral. Whether you have a Democrat district or a Republican district, you shouldn't be walking in and have all Democrats election judges in a Democrat district, nor should you in a Republican district. It should not work that way. How you get to neutral is that you have an equal number of both. That's how you get to neutral. +1, -1 gets you to neutral. And so that's how you get, in effect, neutral, is by having them neutralize, you might say, each other in the administration of the process. That is what enables you to have that trust and confidence, is you have that party balance. That is a good thing, and that's how you get to neutral. One of the things that we did do in past years was enable election judges to not just, it used to be that you had to come from your precinct, but then you had some of those issues. How do you accomplish? So we expanded it so you can go within the county or even county to county and recruit election judges. And there are folks who are in a different area who are election judges. They want to go work as an election judge in inner city Minneapolis. They want to understand the process and system, and they're willing to do that. So, but the point is, to get to neutral, that neutral effect, having party balance is what helps you get there.
Senator Wicklund.
Thank you, Mr. Chair. Senator Kiffmeyer, I had a question, kind of follow up on the election, making that election judge party designation public. As I understand it, the cities today are responsible for finding election judges, or can you tell me who is responsible for finding election judges for elections?
Senator
Who
Kiffmeyer.
performs that role?
Mr. Chair and Senator Wicklund and members, so there are several ways by which you can get election judges. Election judges can initiate on their own, volunteer, sign up, fill out the information. There's also state law that allows political parties to submit a list of election judges, and the local election administrators are required to go to that list first in order to choose election judges, to ask them, just because you submit a list, sometimes there's a little time gap, but they call them and ask them if they're willing to serve. So there can be other precinct caucuses, maybe you've been to some of them, and there will be an election judge sign-up sheet for which you can sign up there. So there are many ways by which you can, the process is to get election judges. In addition to that, if there is a shortage in any way, the local election administrators are also able to contact either major political parties on a state level or some other way to indicate if there is a shortage. That is something that's within it. There is no statutory requirement that county election administrators, though they can put information out there and ask and request, they do so as well in that method that I've known about.
Senator Wicklund.
Mr. Chair, Senator Kiffmeyer, I guess what I was getting at is more who's responsible for, in the end, having enough election judges at each location. Is it the local city administrator, or what would you call that entity? I guess city, township. Do you understand? I mean, I'm not asking how do they come up with the election judges. I'm just saying who is responsible for filling that role.
Senator
Well,
Kiffmeyer.
there are several roles that have responsibilities, but in the end, the local city council, township, county board will approve a resolution appointing those election judges that are presented to them by a local election administrator.
And have,
Senator Wicklund.
Mr. Chair, Senator Kiffmeyer, have those entities been asking for the political party to be a publicly available piece of information for the election judges, so that, I mean, have they been asking for this to be available?
Senator Kiffmeyer.
Thank you, Mr. Chairman and Senator Wicklund. There are many people that make requests in order to have that information. There are several. As far as local elected officials making that request, I don't know of any that have made that request from that level. But when we put bills together, we don't just take local elected official requests. We take general public and others as well that have changes that they want to laws.
Mr. Chair, another question about the different information that's going to be made public if your bill is or goes into effect. You've also established that the voter status history be publicly available for all voters or the challenged voters. If there's mistakes that are within that voter status history, a challenge, stating a challenge, is that something that can be corrected, or is that something that just, if someone feels it's incorrect, is that still just going to be made public? And you've got provision in here that states that their challenge status is going to be made public information. Is that correct?
Mr.
Senator
Chair and
Kiffmeyer.
Senator Wickland, I'm sorry, I was on the election judge issue, and that's why I was puzzled by your question.
I'm sorry, I'm switching topics.
All right. And yes, that is what is in the bill.
Senator Wickland.
And so to my question, Mr. Chair, Senator Kiffmeyer, if there's an error in a challenge, does that information ever get corrected then? This is going to be publicly available?
Senator Kiffmeyer.
Mr. Chair and Senator Wickland and members, so it's not a matter of error, it's a matter of the most recent information. Remember that information comes from the courts, from the Department of Corrections and Public Safety. That information is accurate at the time it is received. However, in cases of felonies, information subsequent to that can come forward that say that the challenge is removed, the felony, the time has been served. And so that is why we have the notice, the appeals, and also the importance of a provisional ballot to help make sure for that time lag that the information is accurate at the time it is received.
Thank you, Mr. Chair.
Okay. Senator Lane, we're trying to get done with this one, so.
Yes, I find it difficult that we keep trying to say that making public which party the election judge affiliates with is a new ballgame. We keep trying to point at this, that this is unnecessary. When I walk in to my voting place, I know that those judges there are 50% Democrat and 50% Republican, but I don't know which is which. And you want that to be public. I consider that an unnecessary violation of their data and the other data that's in this bill. You could be personally challenged as a felon because an error was made administratively, and that would be forever public data on the record that you were challenged as a felon. Yes, it was cleared, but now somebody would look at that and say, this is public data, and the concern we have about data privacy in this legislature should be saying no to both these things.
Okay, a roll call has been requested. Senator Jasinski.
Thank you, Mr. Chair. I would like to move Senate File 514 be recommended to pass and re-referred to the Transportation Policy and Finance Committee.
Okay. Senator Jasinski has moved Senate File 514, recommended to pass, moved to Transportation Policy and Finance Committee. A roll call has been requested. We will take the roll.
Chair Hall,
Yes.
Anderson, Jasinski,
Aye.
Lane,
No.
Matthews,
Yes.
Osmek,
Yes.
Ralph,
Yes.
Torres Ray,
No.
Uyghur,
No.
Wickland.
No.
There being 5 yeses and 4 noes, the bill does pass this committee.
Thank you, Mr. Chairman and members.
Thank you, Senator Kiffmeyer.